Good morning. I'm Paul Truster, Director of Continuing Legal Education for the Law Society. I would like to welcome you to this latest in our series of 6-minute programs. We've done the 6-minute family lawyer, the 6-minute estates lawyer, this is the 6-minute international lawyer. Eventually we'll no doubt get around to the 6-minute securities regulator and the 6-minute admiralty lawyer. But we're very interested in how well the format meets your needs. Some people so far have said 6 minutes is good, 8 would be better. Others have said 6 is just about right. You'll notice in the binder a gray course evaluation form, and if you would be acting, well, put it this way, these are in large measure what guide us in planning programs that will best meet your practice needs, and so you would act in your own self-interest as well as doing us a very great favor if you could complete it through the course of the day and leave it at the registration desk when you leave. If for any reason that's not possible, then please do mail or fax it in afterwards. And as I say, if you have any comments on the effectiveness of or otherwise of the 6-minute format, please do let us know on that form as well. Because we are running just a few minutes late, I'm not going to take up much time in announcements. I'm obliged to remind everyone that this is a non-smoking facility. Those smokes can be grabbed just outside the east doors where you came in, the registrants, not the faculty as I understand, but the registrants each of you should have the green booklet as well as the binder. If you don't, you should be able to obtain a copy outside. And I'd like to thank all our faculty, not all of whom are as yet visibly in place, but to all of whom certainly we're very much indebted. CLE is completely dependent on volunteers who have given very generously of their time and talents in preparing for the program today and in preparing the materials you have, and certainly we're grateful to each of them. It's also my pleasure to introduce the chair of today's program, Jim Klotz. His biography is in the materials, but I'll just note he's a partner in Klotz Associates. His practice focuses on international transactions. He's chairman of the Canadian Bar Association's International Development Committee and of the International Sales Committee, M1 of the International Bar Association, and has published and made himself prominent in the field in many ways. Please join me in welcoming Jim Klotz. Thank you.
Good morning, everyone. Last night, I went onto the internet to find a joke to start off. That'll be a familiar sound momentarily. That was for you, Paul. Thank you. I went to the internet to find a joke. I have found a lot of jokes to tell. Unfortunately, because they're being videotaped, I'm going to have to tell them all to you privately later on. That introduction of myself was the longest one that you'll hear this morning. The bios of all the speakers are in the materials, and we are going to be very much under the gun. Everyone is anxious to speak for slightly longer than 6 minutes, and I will be using a trusty egg timer, which is somewhat accurate to slow people down. Just in terms of the intros, the way that we selected speakers was we had a group that got together. We put our heads together to try and come up with the leaders in their field in areas that affected international practice. We've come up with a good group, and I was just saying to our first speaker that some of the bios in the materials are out of date. They are the bios that were on file with the Law Society and may not have been updated, so I apologize to our speakers for that. However, I will try and keep my remarks super brief. With that, I'd like to get rolling, and I will turn to our first speaker, Riyaz Dattu, who is a partner, Riyaz, with McCarthy Tetro. And that will be the sum total of the introduction. I will set the timer to 6 minutes. This is the critical sign, and that sign means that your time has completely expired.
Thank you. I'm going to cover anti-dumping. Anti-dumping is the trade remedy of choice in Canada. There are other trade remedy measures that one can take. Countervailing is one, safeguard actions is another. You will find, though, that when you look at the listing of cases that are taken by Canadian industry, anti-dumping is far in any measure at the very top. And the reason for that is it's a very effective remedy. It's a remedy that is is more readily available to domestic producers. Countervail has its complexities in terms of accusing another state of providing benefit to their industry. It's more political in nature, and one gets into some difficulty in being able to collect the evidence that is necessary. It also doesn't provide, in terms of the measure of remedy or benefit, the same equivalence as anti-dumping does. Safeguard is a remedy that is used from time to time, but again, not very frequently. It is available where you can show serious injury, and you don't have to show dumping, but it's a temporary measure to avoid the injury, the serious injury that has been caused for a spatial period of time. Again, if you are able to show serious injury, in many cases you're better off alleging dumping and injury caused by dumping, because the remedy that you get is 5 years, and again, you're not subject to political intervention, as is the case with safeguard actions. The procedure for bringing dumping cases is set out in the handout that you've got. If you look at the chart attached to the notes that I've given to you, you will see that the process takes about 9 months from the start, from the date of the filing of the complaint. You can get effective remedy within 5 months. That is when the preliminary determination is made, and the decision of the tribunal is generally about 9 months after the filing of the complaint. The permutations of the procedure are set out in the charts. I won't go through that given the time limitations. But let me talk then about why somebody would bring a dumping case, and number two, what criteria would you have to go through in terms of deciding whether or not to follow through on a dumping case, even where you can substantively show that a remedy is appropriate. Number one, in terms of getting the remedy, the substantive elements, you have to show dumping, and dumping is based on, the calculation is based on the foreign exporter's home market price. That's one of the bases, as compared to the selling price into Canada. The second criteria to have a substantive case on dumping is injury caused by the dumping. The third one is actually slipped into the second one, the causation. Causation is a very important requirement, and one that the tribunal spends a great deal of time investigating. You have to, before you file a complaint, ensure that you have a valid case on all these three grounds. And in terms of the analysis that you have to go through, the causal link would probably be one where you spend most of your time. To give you an idea, in one of the cases that we filed corrosion-resistant steel sheet, we knew that the argument that the other side would be making is that the prices of galvanized steel had dropped in the Canadian market in the year 1992-93, and that was because of the recession. To disprove that, among other things, what we did was we went back and looked at pricing over 26 years from Stelco and Dofasco, and compared the pricing vis-a-vis the recessions that Canada encountered, and there were 5 recessions during this period of time, and we were able to show that in every single recession prior to the 1992 recession, the prices had not gone down. Prices only went down in 1992, 1993, when there was a glut of imports into Canada, particularly from the United States. So by doing this, the analysis on a macro basis, you can decide whether or not you've got a viable case. Now, even if you have a viable case, it may be that the company will decide not to pursue a dumping case. Reasons for that may be there's a great deal of executive time that is required to pursue a dumping case. Legal costs can be significant, so there may be a barrier as to the personnel time and legal cost. There is a concern as well about...
You've still got 2 minutes.
There's still a concern about customer impact. If you follow through with a case, many customers may not be your allies after the fact, and certainly if you're not successful, that could affect your position in the future. There's concerns about retaliatory action by foreign producers in their own home market, retaliating to the dumping case that you bring against them in Canada. There would be concerns about the Competition Bureau getting involved if they feel that the bringing of the dumping case will put you in a dominant position. And Then there's the concern about the trial-type procedures that are used by the CITT, where there's extensive cross-examination. And all of these are significant business factors that may dissuade a company from following through. If there is the decision to go ahead, and if you are successful, the benefits are significant. There's a 5-year protection afforded to the domestic industry, and the level of protection is significant because of the way the margins of dump are calculated. And in all cases that you would see where there's a dumping finding in place, the industry receives, the industry's financial position improves substantially. Let me now speak from the exporter's perspective, keeping the time constraints in mind. Exporters shipping into Canada have to have their antenna up. It is quite surprising, and I suppose it shouldn't be surprising by now, at the level of obliviousness that exporters have when they ship products into the Canadian market. To a great extent, they're relying on the importer to give them information, and that information may not be coming through, or there's lack of communication. The importer can be the antenna for the foreign producer who's shipping into the Canadian market. The importer has to establish whether or not there's a domestic producer who might bring a case, has to keep track of the market share and market share trends of the foreign producers' products in the Canadian market, look at price trends. If the pricing level is going down, that may be a signal that things may heat up to the point where there may be a dumping case. And also keep track of the difficulties the domestic producer may be facing in the Canadian market because of factors other than dumping, such as delivery problems, strikes, quality problems, intra-industry competition within domestic producers that is causing the prices in the Canadian market to drop. So the importer's role is very significant, and those who are advising importers have to keep that in mind, and the importers really are the trigger point for a foreign producer knowing whether or not there's a likelihood of a dumping case. If one gets snared into a dumping case, my time is up.
You're up.
I'm off. Okay.
I can see it's going to be, thank you, Riyaz.
Thank you.
I can see this is going to be extremely frustrating for all of us. We'll try and get used to it. What I will do is when there's 1 minute left, I will give a tap on the microphone, and you'll know that your time is coming to an end. Our next speaker is Scott Fairley, who is a partner with Lang Michener and is a litigator, and is going to speak about sovereign immunity. 6 minutes.
Thanks very much, Jim. I was going to use with only 6 minutes to speak, I was going to use the analogy about wine glasses half full or half empty, but since Jim's using an egg timer, that's probably a terrible mixed metaphor. I'm going to begin with a hypothetical. Assume you are counsel for the Acme Boot Company. Acme thought they had a contract of sale for 10,000 pair of Acme Indestructibles, their top model. They were to be sold to the German Army doing training exercises in Winnipeg through an agent of the German government in Winnipeg. There's been partial delivery. There's been partial payment, but the Winnipeg agent has now informed your client that they've repudiated the balance of your contract, and lo and behold, your client is awash in Indestructibles. Do you have an action against Germany in a Canadian court for repudiation of that contract? Clearly you would if the purchaser was any private entity doing business in Canada, domestic or foreign. You also would if the purchaser was a Canadian government entity, provincial or federal. Whether you do or not against the government of Germany present in Canada is the subject, I guess, of the next 5.5 minutes. The traditional answer is that no, you wouldn't. Absolute immunity, principle of international law, sovereign equality of states. A government will only be impleaded in domestic courts of another state sovereign with its explicit consent. You'll find if you ever run into this that they're quite reluctant to consent. This principle of law was changed primarily in the post-war period and through the 70s as a result of common law decisions which drew a distinction between public acts of government and private acts of government. This all came about as a result of a lot of big corporations used to getting profits out of their deals doing business with central market economies behind the Iron Curtain before it rusted off. And as a result, international law adjusted to that reality and provided for various exceptions to the theory of, to the absolute theory of immunity. So you had a new theory of immunity called the restrictive theory. That was accepted in various common law decisions and then was codified in statutes in various countries anxious to solidify this area of the law. The first major statute was Government of the United States, not surprisingly, Foreign Sovereign Immunities Act of 1976. The United Kingdom followed in 1978 with the State Immunity Act, and we did it in 1982. Australia and quite a number of other countries have followed. For practitioners, state immunity acts arise primarily in the context of domestic lawsuits, for example, the hypothetical I gave you, and a claim of immunity is the most obvious and if successful, complete defense for a foreign government to legal proceedings brought against it. State immunity from jurisdiction falls into three basic categories, and they get more serious as you go through. Jurisdiction to prescribe, that is, whether or not the regulatory structure you're relying on, if it's statutory, applies to the government in question. Jurisdiction to adjudicate, which relates to the court's jurisdiction, and jurisdiction to enforce, carry through in the judgment. The latter two categories are of primary concern to you if you're ever initiating a lawsuit, and are your principal areas of defense if you happen to be retained by a foreign government entity. Now, the substantive exceptions to immunity are outlined in the statute. I briefly summarized them on pages 2 and 3 of the paper. The central one is the one I've already alluded to. That's commercial activity. You also have tort exceptions in respect of injury within Canada, damage to loss of property, admiralty claims, criminal activity, which the State Immunity Act itself doesn't cover. You find that elsewhere. And interest in property arising by way of succession or gift. All of these are exceptions to the general rule. The statute also states a foreign state is immune from the jurisdiction of any court in Canada. So that's your starting point. So you're coming from, if you're a plaintiff, you're coming from behind. On the principal exception to immunity, commercial activity, it means any particular transaction which by reason of its nature is of a commercial character. We went to the Supreme Court of Canada on this. There was the opportunity to erect a bright line test in line with the American example, which the Canadian statute was modeled on. The Supreme Court of Canada did not quite buy it. So we've got kind of a mixed approach in Canada where the courts are going to look to the purpose of the activity which gives rise to the claim. So you've got a bit of a slippery slope. I'm just about out of time. The last portion of the paper gives you examples of recent cases that have been in the courts. Most of them so far have been sometimes controversial tort claims. The snatch and grab case, Yaffe and Miller. There was another one, Walker versus State of New York, where the sovereign immunity defense of the government of the United States was successful, but there's some cabinet activity to try and get around that, given that the result was quite unpalatable. I'd leave the details of the argument to you here. It's unclear whether the statutory regime we have leaves you much better off than the common law cases did prior to enactment. Have to wait and see. That's it.
Thank you, Scott. Moving on, our next speaker is Frank Farfan, who's a partner with Macbeth and Janssen. Frank is an IP lawyer, and he will speak on issues and concerns with gray market goods.
Thanks, Jim. There's a fairly detailed paper in your materials, and in addition, circulating around the room is a couple of pages of notes. I prepared a fairly optimistic 60 copies of those notes, so if you don't have them, look for that. I'd like to focus today just on one recent case and its implications here in Canada for gray marketing, and that's the June 1996 decision in Smith & Nephew versus Glen Oak. Now, this is a case where the court has finally tackled, or finally had an opportunity to tackle square on, a number of important issues relating to gray marketing, which have been outstanding in Canada for decades. And the end result of that decision is that it's probably much harder today to prevent gray marketing in Canada than possibly it may have been beforehand. Now, a caveat on that case, there is presently an application for leave to appeal to the Supreme Court of Canada, which is outstanding. So if that court takes on the case, of course, everything may change yet again. Now, the basic facts in the Smith & Nephew case related to the Nivea trademark, and it involved the importation primarily of Nivea face cream from Mexico, which had been put on the market in Mexico by a subsidiary of the German trademark owner, namely Beiersdorf. Now, so it was a genuine product which had been authorized by the owner of the trademarks internationally. There are some references in the case report to some UK soap also being sold under the Nivea case. Now, the Mexican cream had formaldehyde in it, so clearly it was different from the product which was being sold in Canada, and arguably it could have been presented as being an inferior product. The action in that case was brought by the exclusive licensee in Canada. The trademark owner was not made a party plaintiff to the lawsuit. It was named as essentially a co-defendant in the lawsuit, but it didn't participate in the case. And I think that fact came back to haunt the licensee in that decision. There were 4 important conclusions in the case. First of all, a cause of action which had been at least partially based on Section 7 sub E of the Trademarks Act was found to be unsupportable. The Federal Court of Appeal in this Smith & Nephew case upheld its earlier decisions that Section 7E has no constitutional authority, even in any residual sense. So that's important because a number of the previous gray goods cases in Canada seem to rely on Section 7E, which talked about unfair competition. So this decision has overruled those earlier decisions, meaning now you have to look at those cases with more of a jaundiced eye. The second important point was that this court clearly found that there was no basis for a finding of trademark infringement. The licensee's action was based on Section 50 sub 3 of the Trademarks Act, under which the licensee stood in the shoes of the trademark owner. And the court found that the licensee was in no better position than the trademark owner would have been if it had been the one to bring the action, and that all the defenses that would have been available against the owner were likewise available as against the claim by the licensee. The court concluded that since the fundamental definition of a trademark is that it is used to indicate source or origin of goods, that since the Mexican goods came from the same source as the Canadian goods, namely they all came from or they were all authorized by the German trademark owner, there was no chance for infringement. The licensee also brought an action for passing off, or a claim for passing off as part of that case. The basis for its complaint was a little bit unclear. It didn't necessarily state clearly whose reputation it was relying upon. The court seemed to take it that the licensee was trying to assert the trademark owner's reputation and goodwill that would have been associated with the trademark. And the court concluded that this licensee was not the proper plaintiff to bring that kind of a complaint. That if there was any such complaint in law, it was one which ought to have been brought by the trademark owner, namely the owner of the goodwill, not the licensee. So although that part of the decision I don't think was particularly well reasoned, I think the conclusion was sound because there really is no basis in law that I'm aware of to conclude that a licensee can rely on somebody else's goodwill in order to pursue a passing off claim. The court then went on in Obiter to suggest that it was unlikely that even if the owner had been the one to bring the passing off complaint, that it would have succeeded. So that leaves the options for pursuing gray marketing now to be fairly slim. Theoretically, it sounds like a trademark owner might be able to sue for passing off. He may have a chance of succeeding if the defendants have taken active steps to actively misrepresent that their goods are somehow the plaintiff's goods. If he says if he puts an ad out saying that my products, my gray goods products, are from the authorized source, then the trademark owner could probably stop that. If the goods are inferior, and I draw a distinction between inferior and different, there might also be some sort of a complaint as well. And there's a couple of other possibilities. They're in the materials and they're in the notes.
Thank you, Frank. Our next speaker is Larry Herman, who is a partner with Castles, Brock, and Blackwell. He's a trade lawyer, and he's going to speak on what the practitioner should know about the WTO and NAFTA.
I'm going to leave the NAFTA aside. It's part of the fabric of Canadian law now, and many people have run into it in one way or another in their practice. Leaving aside the rest of the faculty here in the room, how many of you in your practice have had any occasion to have reference to the World Trade Organization agreement? So there are some in practice that have come up against issues concerning the World Trade Organization agreement. Let me very quickly outline some points that you need to keep in mind as practitioners. If you're involved in your practice in the movement of goods or services, the WTO does have relevance. Most favored nation treatment and national treatment are the fundamental rules running through the World Trade Organization agreement. If a client has encountered discriminatory treatment in another jurisdiction, there is a possibility of using the WTO agreement as a means of remedy. Let me explain how. Unlike its predecessor, the GATT, which was a contractual arrangement among states, the World Trade Organization agreement is a single instrument creating an international body, the first, in fact, to emerge on the international scene with universal or almost universal membership since the Bretton Woods agreements after the war. It is a single undertaking with universal membership and entails a collective series of obligations among states. Part of the WTO agreement's achievement, and probably the signal achievement, is the creation of a dispute settlement mechanism that entails two fundamental principles. One is universality. It is open to any government to use, developed, rich or poor. And second is automaticity in the enforcement of the decisions of the dispute settlement bodies. In the first instance, governments are required to consult to see if they can resolve a dispute. If not, that dispute is referred to a panel, and unlike the GATT agreement, or the GATT, where panel reports could be blocked by any government, panel reports under the WTO agreement cannot be blocked and enter into force automatically. I'm using the term somewhat loosely, but enter into force automatically. A panel report can be appealed to an appellate body, but ultimately the panel report is required to be adhered to by the losing government. That means that if a client of yours faces market access problems in another jurisdiction, which arguably infringe that country's obligations under the WTO agreement, you can, through representations to the government of Canada, ask the Government of Canada to bring that matter forward. Ultimately, if successful, the offending measure will be removed, and in an indirect way, admittedly, your client will be able to achieve relief. Two further points. Dispute settlement isn't the only achievement of the WTO agreement. It is a huge instrument covering a wide range of sectors, and there are many other aspects of it that we haven't touched on, including reform of the agriculture sector, definition of subsidies, and other things to the benefit of any enterprise engaged in the movement of goods and services internationally. And secondly, as you all are aware, there will be a series of reviews of the WTO agreement through ministerial meetings. The first one of a regular series is coming up next month in Singapore, and you will follow it, no doubt, in the press with great interest.
Thank you. Thank you, Larry. Thank you for being so prompt as well. Our next speaker is Peter Glossop, who is a trade lawyer with Osler Hoskin, who will speak about what you need to know about the Canada-Israel Free Trade Agreement.
Thanks. And I also will try to be a soft-boiled egg here, so I'll be very quick. I guess one question in people's minds, even before they want to understand the agreement, is why is Israel interesting? Israel right now is actually enjoying an economic boom, and there's quite a bit of growth, exports, stable inflation, and strong domestic demand as a result of a lot of recent immigration and a growing middle class. Really, it's quite a success story. If you set aside the political difficulties, it's quite an economic success story in the Middle East. The other thing that's very important to bear in the back of your mind is that Israel is the only country which has a free trade agreement with both Europe and the United States. With the free trade agreement that Canada wants to enter into with Israel, Canadian exporters are going to be in a position to better compete against their American and European counterparts and take advantage of the program of privatization and economic reform in Israel. The agreement is going to be implemented by Bill C-61, which received second reading on October the 10th, and the intention is that the agreement will be in force in January 1997. The main feature of the agreement is the elimination of tariffs on industrial goods. This is quite a basic agreement, but what it does quite well. Essentially, with two minor exceptions, all industrial tariff goods will be eliminated in January. And this is quite important when you think about the composition of our trade with Israel. We don't have a huge amount of trade with Israel, but what we do have represents principally industrial products. Last year, we exported about $216 million worth of products to Israel, and 60% of these consisted of 5 products, aluminum, vehicles, and machinery being the major ones. All of these are going to get into Israel duty-free in January. Coming into Canada, Israel sells approximately the same as we do to them. Again, 2/3 of their exports consisted of 5 products, all industrial products. All of these will be duty-free entry into Canada in January. The other main benefit for Canada is going to be the reduction of tariffs and increased quotas on access into Israel for our food and agricultural products. Historically, this hasn't been a very strong area of trade. Only $17 million worth two-way trade last year. But we're now going to be in the game against the United States and Europe in selling our food and agricultural products. In terms of the technical aspects of the agreement, there are rules of origin which are designed to ensure that the tariff concessions are given to Canadian and Israeli goods, but they're a lot simpler and more relaxed than those in NAFTA. The agreement's got some provisions on emergency procedures in the event of a surge of imports. There are some customs procedures which are important for practical purposes, and there is a basic dispute settlement mechanism. As I mentioned, it's a basic agreement, so it doesn't deal with a lot of the things that you would find in NAFTA or in the WTO agreements. Things like government purchasing, services trade, anti-dumping, and subsidy are all dealt with elsewhere in the WTO. Another important thing is that in terms of immigration issues, business transfers, people going to Israel to work on projects and that type of thing, there isn't going to be any special entitlements for Canadians going over there or vice versa. Couple of points on the special provisions in the agreement. I call this completing the triangle. If you imagine a triangle with Canada, the United States, and Israel, what this allows is more practical and really quite liberal system for taking advantage of the agreements that Canada and Israel currently have with the United States. Two things here. First of all, U.S. origin products which qualify for tariff preferences into Canada under NAFTA or into Israel under their agreement are going to be considered essentially Canadian or Israeli if they're used in further manufacturing in Canada or Israel. So the difficulty one would have encountered with U.S. origin contamination, in effect, U.S. origin goods contaminating, is avoided. The other thing is a very liberal system, in my view, of allowing minor processing to occur in the U.S. if Canada and Israel can agree on some procedures by the beginning of next year. Very liberal provisions. I've outlined some of those in the paper. And that's it.
Great. Thank you, Peter. Our next speaker is Brian Gray, who in a moment will speak on the effective and economical use of the International Intellectual Property Treaty System.
Yes, what I'm speaking about is not what's in the paper materials, which is patents in a nutshell, which you can read when you have insomnia or something like that. But, actually, I'm going to cover the whole intellectual. Frank will be impressed by this. I'm going to cover the whole intellectual property treaty system and all the international conventions in 6 minutes, and also I'm going to tell a joke, or two jokes actually, which I think, since my children told them to me, are probably okay to be videotaped, Jim.
Okay.
And actually they're appropriate. I don't know if any of you have heard these, because they're appropriate for a bilingual country like Canada, or at least temporarily anyway, bilingual country. My children like to make puns in French and English, and it's sort of peculiarly Canadian because you have to know a little French and a little English, probably not too much of either, and my children call these franglais jokes. So I don't know if you've heard of this. The typical franglais joke would be something like this. How do you say 3 cats sank in French? In franglais, I should say, not in French, but in franglais. Well, it's simple. 1, 2, 3, 4, 5. So, how do you say a lawn mowing in French? In franglais, I should say. Well, that's also pretty simple. Coup de grace. Anyway, my children thought it was funnier anyway. Okay, now to the international treaty system. I didn't have a chance to try this ahead of time. Basically, the point I want to make in the short time I have available is that the international treaty system in intellectual property has been around a long time. It is the oldest, really the oldest form of harmonization, of legal harmonization, other than the postal union, which I don't really count as legal harmonization. In 1883, the Paris Convention was established for patents and trademark filing, and in 1886, the Berne Convention for copyright protection. These matters were further harmonized and made, and the filing system was made more uniform in the Patent Cooperation Treaty in 1970, which Canada adhered to in 1990, and further standards, minimum standards of protection were specified in NAFTA and then later in GATT. Oh, sorry, do you want to? It's not. The international treaty system provides for really minimum standards of protection. I mean, you're used to, if you have to deal in foreign countries, you'll find that there are difficulties meshing the languages, the legal traditions, and the concepts of those countries with your own understanding. But in the intellectual property field, the treaties provide for reciprocal treatment. In other words, these countries must provide for the same form of treatment to you as they would provide for their own nationals. They have to give you their minimum standards for protection for patents and trademarks. And the most important 2 points really about the treaty system are, in my view, 3 and 4 and 5 really, which is the conclusion, that the treaty system provides for a recognition of a national filing in Canada. It provides for cost deferrals so that if you file in Canada first, then you get certain rights established automatically from the Canadian filing, and it provides a window to international trade and licensing in those countries. Without leaving Canada, I just want you to remember just one point, if you remember nothing else from this talk, is that without leaving Canada, by filing an application in English in Canada, you can create rights in foreign countries. Now, I defy anybody to tell me in any other legal area, area of law where that can happen. And certainly, even now with securities regulation and attempts at harmonization in other areas, there are no, as far as I'm concerned, there is no other area of law where by filing a document in one country, in Canada, in your home country, in English, you can create rights in other countries. So, for instance, a trademark application filed in Canada is given recognition for priority purposes in almost all countries of the world if it's filed in those countries within 6 months. And whether that's Russia, Israel, Italy, Korea, Macedonia, or Mauritius, or countries that most of you and I have never even heard of. And there's a great deal of flexibility because nobody requires you to file in those other countries. You simply have 6 months in which to do it, and your client may have an interest in one particular obscure country or one major country, but not in others, and it has the flexibility to decide where it wants to file once it's established its rights by filing in Canada. And the cost of filing in Canada is relatively small when you consider how much money that companies generally diddle away on other things. You're looking at less than $1,000 in the case of a trademark application. If a company has any international or wannabe international idea of selling in other countries, and that includes the United States and Mexico, for instance, it seems to me foolish not to establish its rights by filing an application in Canada. There is a community trademark convention which enables a single application to be filed in Europe. It's in the Community Trademarks Office in Alicante in Spain. That covers 15 European countries, and that application can be made based on the Canadian priority. The application costs about, well, it depends on who you use, but between $4,000 and $6,000. And the EU is a market of 360 million people. So it seems to me that is something which is a small price to pay for the access to that kind of market. The patent system I'm not going to have time to cover. I have covered some of it in my paper, but the same sort of system exists except you have 12 months. If you file a patent application in Canada in English, you have 12 months to file in other countries. If you use the Patent Cooperation Treaty, essentially you've made a PCT world application within 12 months. You now have, after filing in Canada, and you file 12 months later under the Patent Cooperation Treaty, you have a central examination in the central search at The Hague in Holland, a central examination in Munich, and you do not have to incur the expense of the national systems of filing in other countries until at least 30 months after the filing, after your initial priority filing. So you can defer those costs. So the basic point is, file a national case. If your client is interested, then you can pursue the matter in other countries. The costs go up and up and up and up and up, but that will only be pursued if the business is there to justify it. Otherwise, you can abandon the case. But if you don't file a national case, you don't have any rights to start off with, and you've got a problem. Thanks.
Brian, thank you. I'm terribly sorry to
That's all right.
cut you off. Our next speaker is Charlotte Janssen, who is a principal of their own firm, Janssen Associates, and who will speak on tips on useful jurisdictions.
Okay. I'm focusing mostly on offshore jurisdictions, not on North America, just for interest's sake. The bulk of my client base consists of wealthy individuals seeking to immigrate to Canada, or alternatively, Canadian and foreign financial institutions and developers who wish to, who are involved in international transactions. The main reason for incorporating companies or establishing trusts outside of Canada really are tax motivated. However, I noticed yesterday afternoon when I got my my list of speakers today that Mr. Owen from Thorstenson's will be speaking about the tax haven aspect of offshore jurisdictions later on today. So I will try not to focus on tax issues and have instead tried to direct my attention to jurisdictions that you might choose for various tax reasons and non-tax considerations that clients look at in choosing jurisdictions. Firstly, I think you cannot underestimate the benefits to anyone doing international business of a well-thought-out tax structure. The primary thing one will look at, of course, especially for Canadians, is the treaty structure and whether your clients can have tax savings as a result of structuring their activities in two countries with the benefit of treaty protection. Secondly, and especially in the cases of companies engaged in international trade or marketing or licensing of technology or services, you may consider whether it's advantageous to structure your clients' affairs through international business corporations, commonly known as IBCs. What is important about those, especially in case of Canadian companies, is that if your international business corporation is located in a treaty country, or in some cases non-treaty countries, they may be on the list for Canadian exempt dividend treatment, which means while enjoying as little as a 3% tax rate on your business in these jurisdictions, you might be able to take your dividend income home tax-free. That type of benefit doesn't exist because for other types of income, such as royalty or interest income, since you have problems returning money back under the treaty, since when you have an IBC, even if it's in a treaty company, you do not, the treaty does not apply. And there's some anomaly, which hopefully Mr. Owen will explain to you better later on, about why you should be able to take home dividend income tax-free as a listed country. Countries in which we generally incorporate IBCs are Barbados, Cyprus, Jamaica, and I know I've spelled this wrong, but there's also now one out of Malaysia called Labuan, which I noticed Mr. Owen mentions in his paper. I've spelled it wrong in my paper. I've only just learned about it. But these Barbados, Cyprus, and Jamaica do have treaties with Canada, and as a result, you can take advantage of that anomaly on the exempt dividend provisions. Other clients, primarily clients who have nothing to do with Canada, can still take advantage of the traditional tax haven countries, or the no or little tax jurisdictions. When choosing these tax havens, in addition to the fact that they don't have tax, most of my clients consider factors such as the acceptability of the jurisdiction for international contracts with third parties, the availability of good local counsel, the stability of the government and legislation in that country, the general reputation of the country as a tax haven, accessibility to the country by plane and telephone, time zones relative to the home jurisdiction, and in cases, especially when I'm representing from Canada, available of, that's the time zone issue, and then also finally the availability of acceptable administration and accounting advice to service any sort of domicile requirements you need to make your structure effective. When considering the traditional tax havens and even some of the more non-traditional tax havens, countries of choice of late, at least for my clientele, have been the Republic of Ireland, which has non-resident corporations, both limited and unlimited liability companies, Jersey, Guernsey, British Virgin Islands, Cayman Islands, and Bermuda. For clients with absolutely no connection to Canada whatsoever, I also take advantage of one of what I consider Canada's best kept secrets, which I'll mention briefly at the end of this address if Jim hasn't cut me off. Finally, other practitioners use other tax havens such as Turks and Caicos, Bahamas, Mauritius, Antigua, Belize. I've Myself and my clients have tended to shy away from these jurisdictions, largely due to their general reputation for more aggressive tax planning. And in cases which are predominantly serviced by U.S. financial institutions, certain of my clients are concerned about the tendency of the U.S. government, oopsie, is that the end? 6 months, 1 minute, okay, to have extraterritorial application on their laws. Finally, for Canadians, you can use some tax havens for very specific purposes, primarily trust purposes. Therefore, I do use Jersey, Guernsey, Cayman Islands, and Bahamas quite often for offshore trust structures for immigrants and inheritance trusts. Non-tax considerations usually are confidentiality and secrecy. Clients might want to look for a jurisdiction that has bearer shares that have no financial disclosure, while Caribbean jurisdictions such as Cayman and BVI are popular for that. I think increasingly Jersey, Bermuda, and Cyprus are coming onto the scene. Important there is I find they work best for cash or investment holdings only when you have a client which is actively in business. The issues of confidentiality can actually work against you because it's very difficult to get banks or Western companies to deal with companies from these countries if there are no financial statements or strict evidence of ownership. Finally, the last tip before he cuts me off is in Canada, we have what could be considered a tax haven for people having no business in Canada and nothing to do with Canada, and that is if people recall the pre-1964 companies, non-resident corporations in Canada. If you are lucky enough to find a jurisdiction which has a healthy pre-1964 incorporated company, you can continue it into the province of Prince Edward Island, which has no residency requirements for directors, and you still may be lucky enough to enjoy the non-resident treatment here as well. Thank you.
Thank you, Charlotte. Our next speaker is Greg Kanagelidis, who is a tax lawyer with Blake Castles, and he's going to speak on practical aspects of minimizing customs duties.
Thanks. All goods imported into Canada are subject to customs duties. In some cases, customs duties have been reduced or eliminated by an international free trade agreement that we've heard about earlier today. But in order to claim the preferential rates, the goods usually must meet complex rules of origin. Where this is not possible, the higher rate of duty continues to apply to the goods. So therefore, it remains worthwhile to structure transactions so as to minimize customs duties that are still imposed on imported goods. And lawyers can assist their importing clients to do so. Total customs duties payable by an importer are a function of the value that must be declared for customs purposes and the tariff rate applicable to the particular goods that must be applied to that value. In planning importations for clients, therefore, we attempt to minimize either the value for duty or the tariff rate. In addition, we structure things so that a client may defer customs duties or claim a drawback or refund of customs duties payable. Let's turn first to how to minimize value for duty. I set out 5 planning points in the handout materials. The first planning point is find the lowest sale for export to Canada. Let's take the simple example. Your client is a U.S. manufacturer of goods who sells to a Canadian customer. The value for duty is based on the price charged by the U.S. client to the Canadian customer. This is the highest value possible. Consider having the U.S. client sell goods to a newly incorporated Canadian subsidiary and not directly to the Canadian customer. The value for duty will be based on the sale to the Canadian subsidiary and not on the sale to the Canadian customer by the Canadian subsidiary. However, the Canadian subsidiary must have sufficient substance in order to qualify as a purchaser in Canada. To the extent your U.S. client is not the manufacturer of the goods but acts as a distributor for an offshore manufacturer, consider having the goods drop shipped by the offshore manufacturer directly to Canada and stored in a public warehouse prior to any sales being concluded with a Canadian customer. Under this structure, the sale price charged by the offshore manufacturer to the U.S. client forms the basis for customs value and not the price charged by the U.S. client to its Canadian customer. A Canadian subsidiary or a Canadian branch of the U.S. client could also achieve the same result. The second planning point is unbundle the price paid or payable. Often, the price charged to a Canadian customer includes charges for related services, especially where the sale is between a foreign parent and a Canadian subsidiary. Charges for the acquisition of the goods should be separated from charges for other services. This will remove the customs duties otherwise payable on the related services portion. The value for duty is determined by ascertaining the sale price and then adding certain statutory additions and subtracting certain statutory deductions. All are set out in the Customs Act. Therefore, planning points 3 and 4 are minimize required additions and maximize allowable deductions. Each of the required additions and allowable deductions are set out on page 4 of the handout materials. An example of a required addition is a royalty payment. Due to recent CITT jurisprudence that largely supports Revenue Canada's broad interpretation of this addition, you may wish to consider avoiding structuring transactions to include a royalty payment at all, or at least consider avoiding having the royalty calculated as a percentage of the value of the goods. Instead, consider a general payment unaffected by the value of the goods. Planning point 5 is don't forget about rebates or discounts. They serve to reduce the value for duty, but only when effected before the goods are imported. There is an exception for cash discounts, such as for prompt payment, which can reduce the value for duty at the time of importation if the importer intends to claim the discount and does so after the importation. Recent CITT case law has indicated that a formula price based on factors beyond the control of the parties may serve to reduce the value for duty even where the final price is determined after the goods have been imported. Let's now turn to minimizing the tariff rate. I also have 5 planning points for you to consider here. The first point is to, first of all, determine the correct tariff classification of the goods. This is not always easy depending on the nature of the goods involved. The second point is, after determining the proper tariff classification, check to see whether a tariff code applies to the goods so as to reduce or eliminate the tariff rate. The tariff codes apply in one of the later schedules to the customs tariff, and they're based on the particular end use of the goods in question. The third point is, find the most beneficial tariff treatment. The tariff rate applicable to goods coming from WTO member countries is the most favored nation rate, which also happens to be one of the highest. However, Canada has granted more favorable tariff rates to goods of certain countries as part of its various trade agreements. There are 11 tariff treatments available in total. Depending on the source of the raw materials used in producing the good and the location of processing and production, a lower duty rate may be available in respect to the goods. The fourth point is, in drafting supply agreements, ensure the foreign seller or manufacturer agrees to provide a certificate of origin or other evidence of the origin of the goods. A certificate or other evidence is always required to claim a preferential tariff rate than the standard most favored nation rate. But if the foreign seller doesn't agree to assist the importer is out of luck. The fifth point is, apply to the Department of Finance for a discretionary remission order. Section 68 and 101 of the Customs Tariff set out the parameters of the minister's discretion and the conditions necessary for obtaining relief. After you've assisted your client in minimizing both the value for duty and the tariff rate, you can further assist your client in deferring the customs duties that end up being payable, if any, by setting up a customs bonded warehouse.
You can finish your sentence. Speakers, you can finish your sentence.
I can't finish it for you.
Our next speaker is Bernard Lette, who's a commercial lawyer with Lette Witterick, who will talk about exclusive distribution agreements under European law.
Thanks, Jim. When I say European law here, I'm referring to the provisions in the Treaty of Rome relating to competition law in the European common market. It's important to understand that when the Treaty of Rome was signed, the provisions concerning competition law were seen as being crucial to the creation and the maintenance of a common market, that uncompetitive behavior by companies in the European common market could have an effect on the free movement of goods, in particular within the member states. Therefore, Articles 85 and 86 in particular, and 87 and 88 as well, were put into the treaty and have an effect on exclusive distribution agreements. The European Commission defines exclusive distribution agreements as agreements by which one party, the supplier, agrees to deliver certain products only to the other, the distributor, for resale within a certain area. No surprise there. Now, considering that agreements of that nature can affect competition negatively, by restricting the freedom of parties to sell goods within certain parts of the European Union, but also in some cases positively by allowing particularly small and medium-sized companies to more effectively distribute their goods. The European Commission, under Article 85, introduced a regulation to that effect. Now, the basic principle of community law in this regard is that an exclusive distribution agreement falls within the prohibition of Article 85(1) when it impedes re-export of the contract products by the distributor to other member states or hinders imports of such goods by third parties from other member states. The leading case is the European Court of Justice case of Constant and Grundig, as a result of which an exclusive distribution agreement is deemed to fall under this article insofar as it confers on the distributor absolute territorial protection. This principle has been upheld many times by the Commission, and the Commission has not hesitated to punish the maintenance of export bans by fines. Regulation 1983/83, to which I referred to before, offers a block exemption which exempts certain types of exclusive distribution agreements from the prohibition contained in Article 85, Paragraph 1. That regulation expires December 31, 1997. The scope of the regulation is that it applies only to exclusive distribution agreements. Therefore, non-exclusive agreements that contain territorial protection clauses don't benefit from the block exemption and may have to be notified to the Commission for consideration for an individual exemption. And if the real purpose of the agreement is anything other than exclusive distribution, then the regulation will also not be applicable. The block exemption offered in the regulation only applies to agreements relating to goods for resale, does not apply to services. Where goods and services are both provided, then it will apply if the charge for the goods exceeds the portion of the charge relating to the service element. The hiring or leasing of goods is considered generally to be more in the nature of a supply of goods than a supply of services. Now, under the block exemption, an agreement will be exempted if certain conditions are met. The supplier can be restricted to supplying only the distributor in the territory and not to supply the contract goods to other users in the contract territory. The distributor, on the other hand, can be required not to manufacture or distribute goods competing with the contract goods, to obtain the goods for resale only from the supplier, to purchase complete ranges of goods or minimum quantities, to take measures for the promotion of sales, to sell contract goods under certain trademarks, and to refrain from any action outside of the contract territory, in particular seeking customers. The block exemption, however, will not apply if manufacturers of identical goods enter into reciprocal exclusive distribution agreements between themselves. Any attempt to limit or restrict imports in the common market means that the benefit of the block exemption is not available. The same applies if users can obtain the contract goods only from the exclusive distributor, as there has to be real possibility of parallel imports. Generally, agreements under which one party appoints an exclusive distributor outside of the common market will not fall under Article 85(1), since such agreements do not have the object or the effect of restricting competition within the common market. This also applies when both parties are situated within the European Union, but the contract territory is outside. Article 85, Paragraph 1 may apply, however, where the agreement covers both member states and non-member states. Distribution agreements for imports into the EEC are governed by the same rules that apply when both parties are situated within the EEC, and the regulation applies. Thank you.
Thank you, Bernard. Sorry to cut you off. Our next Our next speaker is Selma Lussenburg from Borden and Elliott, who will speak on choice of law and governing law clauses.
Thanks, Jim. Can you all hear me? I'm going to take a very practical approach in the 5 minutes that are allocated to me. I have prepared a paper, and it is available on the front corner there. Please be sure to pick up a copy. I'm going to focus on choice of law and forum issues, and it's impossible to look at all of the issues that arise in 5 minutes, so I want to look at it very practically. First of all, what is a choice of law and forum clause? It's that clause that we all see in agreement which says this agreement shall be governed by and interpreted in accordance with the laws of Canada and the laws of the province of Ontario. Hopefully it will go on and will say each party agrees to submit to the jurisdiction of the courts of Ontario, or even possibly irrevocably submits. And that brings me to the first issue I want to speak about very briefly. You have to turn your mind to, when drafting this clause, whether or not irrevocable submission is in your client's interest or not. Increasingly, we are seeing the Canadian courts willing to accept the jurisdiction of foreign courts to determine issues which are the subject of Ontario law. The defense of foreign non-convenience, which has been raised in the past, is not always available to a defendant today. Therefore, I think you carefully have to consider where the assets are located, where your client's assets are, where the other party's assets are, and where is the balance of convenience, where is it likely that litigation will arise. And I think that's really a function of the nature of the commercial contract. And there's no easy answer in my view, and certainly in my experience, as to whether you should agree to a foreign choice of law clause or a local choice of law clause. I do think what is essential is you have to try to assess, in the terms of the contract, who is likely to be enforcing against who, and do you think that you would be able to enforce a foreign judgment in that jurisdiction? That's my first point that I want to raise. The other very obvious point I want to raise is do include a governing law clause. This seems really obvious, but people often postpone those issues that they can't decide on. Business people say, it's too difficult, it's only a lawyer's issue. It's not a lawyer's issue. It goes to the fundamental terms of the contract. It goes to the way your representations and warranties will be interpreted. If you are selling consumer products, you may be subject to certain consumer product liability that you cannot contract out of. However, had you drafted your agreement better with your local supplier, you may be able to give yourself some protection from collateral representations or warranties, to be able to ensure that the local supplier advises you of local consumer protection laws and also of local safety standards which you are expected to comply with. So it is very important to look at that issue, to look at the market in which you're doing business. And again, the issues vary depending on whether you are looking at a distribution agreement or whether you're looking at a joint venture. Typically, when you're conducting a joint venture in a foreign country, I'll use Chile as an example, you would choose Chilean law for several reasons. One is because the Chilean law requires you to be governed by Chilean law. That's a good reason. But also, practically speaking, that's where you're going to be performing the contract. And in that context, you must look at the local issues under Chilean law. Another issue which arises when you are looking at the terms and conditions of your contract are payment obligations. And my preference always is to have a single governing law clause. Sometimes we see very cute governing law clauses where one part of the agreement is governed by one jurisdiction, another part is governed by another jurisdiction, because the parties couldn't come to agreement. And again, it's a recipe for disaster. The only circumstance in which I think it makes sense to have a hybrid governing law clause is when there are multiple transactions which are related and where there are certain obligations which are purely local. And we often see that in the context of enforcing a payment obligation. If you're looking to take security, for example, or a title retention clause in your assets, if you're looking at an international sales agreement, it may well make sense to have local law govern the payment obligation or the security agreement. I draw to your attention that there are different laws regarding the rights of secured creditors, both secured and unsecured creditors in different jurisdictions. It came as a surprise to me a little while ago to find out that in Argentina, unsecured foreign creditors rank after local foreign creditors. We as Canadians would have presumed that all unsecured creditors, it's not great to be unsecured anyways, but you would have thought you all rank equally. That's not the case under Argentinian law. And those are little things that you've got to look out for. It does pay to retain local counsel. Certainly in my experience, clients are often reluctant to incur the additional cost of having local counsel involved. What I find is a good A good compromise solution is to be involved in the original negotiations and drafting of the documents, and then the final draft, send that down to local council, and then review it with local council to ensure that their understanding and your understanding, those assumptions that you make in preparing your agreement, are equally valid in that jurisdiction as they are in your home jurisdiction. One last point is the issue of language. Try to avoid multiple languages, which often happens, and that's usually a function, again, of local law, where it's a requirement that the contract be in the French language or in the Spanish language, and we see two different interpretations, the English contract and the Spanish contract. The terms and conditions in the annex are in English and the main agreement is in Spanish, and the two conflict. You've got to address that issue at the outset, and clients don't like to address those issues because they see those as dollars and cents issues, and I agree with them. However, it's far more costly at the end of the day if at that point in time you've got to start looking at a translation. Read my paper.
6 minutes, bang on. Thank you, Selma. Our next speaker is Donald Marston from Osler-Hoskin, who will be speaking on international performance guarantees dealing with risk of abusive calls.
Thank you, Jim. In my 6-minute limitation period, I will do my best to identify the topic, to describe to you the extent of the problems that can arise, and to suggest an approach that may be helpful in dealing with this topic, and that is dealt with in more detail in my paper and also in the shiny green booklet that I brought along, being the illustrative forms of performance guarantee and counter guarantee security, produced by the International Construction Projects Committee of the International Bar Association. What I'm going to talk about this morning is security of performance on international construction projects. As I'm sure you are all, most of you are all well aware, the approach taken on Canadian and North American contracts is typically to require surety performance bonds. That is not the case on international projects. The use of surety bonds outside North America is extremely rare. What happens on international projects is that owners, or employers as they're often referred to by international construction contract jargon, require what they call performance guarantees. These are really bank letters of credit, demand, irrevocable, unconditional letters of credit that entitle the owner to cash in the event that the contractor is in default and the owner determines that the contractor is in default. Further complicating the jargon aspect is the fact that sometimes these performance guarantees are also called performance bonds, but obviously they're not performance bonds by North American standards. They are bank letters of credit, and it's extremely important to focus on the nature of the security that is being required and to factor that into the important risk assessment process on each project on a project-by-project basis. Letters of credit, by the way, have become increasingly popular on North American contracts too, where the owners are able to negotiate or demand and get away with requiring the letter of credit security in lieu of or perhaps in addition to bonds. Where the risk assessment process indicates that there is a very high degree of risk, that there may be an inappropriate or abusive call, then a contractor is faced, obviously, with a dilemma. Does the contractor bid the job? Does he walk away from the job? Does he plunge ahead and hope that all works out well? Most times, I think things do work out well. But historically, there have been considerable problems in this regard. And let me just try and summarize quickly the nature of the problems. During the 1980s in particular, many complaints were made to the International Bar Association with respect to abusive calls on international performance guarantees. I don't want to generalize, but since everybody probably wants to know, well, where is this most likely to happen? You never know where it's most likely to happen, but I can tell you that historically, most of the complaints related to certain, and I emphasize certain, Middle East jurisdictions. My own experience in dealing with Middle East jurisdictions has not been a negative one in terms of letters of credit performance guarantees. So again, I emphasize that it's a matter of project-by-project risk assessment. I would also caution that on the basis of recent experience last year, I was involved in a project where the contractor alleged an abusive call, and that was a project in one of the Eastern Bloc countries. Fortunately, we were able to get injunctive relief because the performance guarantee, the bank letter of credit, was in fact issued by a bank in Finland, and Finnish counsel was able to persuade the court that an interim injunction was appropriate. How then to deal with the situation where a more even-handed approach is desired to create a better balance as between the owner's entitlement to call this performance guarantee and the contractor's dilemma in proceeding given the risk. This led to the development of these IBA illustrative forms. Early on, the committee that was preparing these forms was hoping for a 2-page standard form document. It's too complicated an issue. Obviously, on any particular project, there are a variety of issues, many issues that develop. Some of the types of issues we heard of in the last speaker's presentation in terms of governing law, for example. Choice of banks, another issue. Term to expiry of the performance guarantee. Let me move quickly in the last minute. I don't know if I can do this in 60 seconds, but the concept in the IBA forms is this. The contractor is required to put up the performance guarantee, but it's a conditional one. This document introduces a conditional aspect. If the owner makes a call and the contractor doesn't object, the owner is paid immediately. So the owner's happy. The owner gets his money right away. If the owner makes a call and the contractor objects, the owner is paid immediately, provided the owner posts a counter guarantee on the condition that the disputed question is heard before a referee or before a body that's empowered to make a swift provisional decision on whether or not the contractor has been prima facie in material breach of contract. And if that decision is in the contractor's favor, the contractor gets paid back from the counter guarantee. That's the concept. If the owner objects, if the owner makes a call and the contractor objects and the owner doesn't post the counter guarantee, then the owner can wait it out and wait for the decision of the referee. We chose the ICC pre-arbitral referee decision-making process because it's designed for swift provisional decisions, 8 days to respond to a request for the appointment of a referee, and 30 days for a decision, 30 days, in completing my sentence, 30 days to respond with a decision after receipt of the file. Thank you very much, ladies and gentlemen.
Thank you, Don. That's great. Our next speaker is Jim McIlroy of McIlroy & McIlroy, Inc., I see, who will speak on the NAFTA's New Frontier Trade in Services.
Thank you, Jim. My first question is, how do I turn on this, just this button here? Am I going to get penalized for this time wasting?
100%.
Thank you very much. Good morning. I'm going to start off with a line that Bill Clinton's been using a fair bit. I won't talk about bridges to the 21st century, but I would like to say that as we move into the 21st century, I think that every lawyer should have a basic understanding of the services sector and the international treaty framework that governs trade and services. And I'm referring to the multilateral General Agreement on Trade and Services, the GATS, and the trilateral North American Free Trade Agreement, the NAFTA. Why? Because I think the services sector is simply too big for anyone to ignore. In Canada and other industrialized countries, services represents about 3/4 of the economy. And I would therefore find it very hard to believe that there's anyone in this room who has not represented a client in the services sector. So during the next 6 minutes, or five and a half minutes, I will confine my remarks to some of the key provisions of the NAFTA's basic services chapter. I want to focus on the NAFTA because it is more comprehensive than the GATS, and because the new frontier it has created is closer to home for most of you and your clients. But first of all, let's make sure we all understand what I mean when I use the term services. Sometimes the services sector is compared to the manufacturing sector in somewhat unflattering terms. For example, we've all heard about Canada becoming a nation of hamburger flippers with low-paying, part-time services jobs. However, I think the services sector goes far beyond the food retail business. When I use the term services, I'm talking about an extremely broad range of economic activity, including distribution, education, transportation, telecommunications, financial services, for example, insurance and security services, and last but not least, professional services, for example, accounting, engineering, construction, computer, healthcare, and of course, legal services. My materials are in tab 12 of your materials, and they include a copy of the first page of the NAFTA's table of contents. You'll see that it's on page 12.5 with the marking at the top of the page in the middle. You can see that Part 5 contains 6 chapters dealing with investment, services, and related matters, including Chapter 12, which is entitled Cross-Border Trade in Services. Let's turn now to page 12-7. Again, I'm referring to the numbering at the top of the page. And let's look at the NAFTA's 3 primary service obligations, which are national treatment, most favored nation treatment, and local presence. NAFTA's Article 1202 is in the top right-hand corner, and it defines the national treatment that a country must accord to foreign service providers. The first paragraph of Article 1202 states, each party shall accord to service providers of another party treatment no less favorable than it accords in like circumstances to its own service providers. Please also read the second paragraph of Article 1202 and note that national treatment does not require that Ontario treat someone from New York the same way that New York treats someone from Ontario. That's called reciprocity. National treatment only requires that Ontario treat someone from New York the same way that Ontario treats someone from Ontario. In other words, Ontario cannot discriminate by treating an American or a Mexican in a manner more onerous than it treats its own residents. Now, the second key NAFTA obligation is the Most Favored Nation, or MFN obligation, contained in Article 1203, and it states, each party shall accord to service providers of another party treatment no less favorable than that it accords in like circumstances to service providers of any other party or of a non-party. And Article 1204 commits each NAFTA country to provide the better of the treatment required by Articles 1202 and 1203. For example, if an Ontario professional licensing body, for example, the Law Society of Upper Canada, treats an applicant from an American state more favorably than it treats an applicant from another Canadian province, the treatment provided to the American must usually be accorded to the Mexican applicant, subject to a special rule that exists for licensing and certification requirements. Now, the third key NAFTA services obligation is contained in Article 1205, and it prohibits Canada, the United States, or Mexico from imposing territorial residency or local presence requirements on cross-border service providers. Article 1205 states, no party may require a service provider of another party to establish or maintain a representative office or any form of enterprise, or to be resident in its territory as a condition for the cross-border provision of a service. The local presence obligation raises some interesting questions. For example, if a licensing body requires a professional to maintain records in a province or state, could this be construed to be a local presence requirement? In addition to the foregoing 3 obligations, which apply to services in general, you should also be aware that the NAFTA created another set of obligations specifically targeted at professional services. Articles 1210 and 1213 and Annex 1210.5 should therefore also be consulted. It is also important to note that Article 1206 permits each country to file reservations that exclude certain measures or sectors, subsectors, or activities from some of the obligations contained in Chapter 12. An Annex 1 reservation grandfathers existing non-conforming measures, whereas an Annex II reservation preserves the power to enact new nonconforming measures in specific sectors. So that's it in a nutshell. Everything you ever wanted to know about services, but were afraid to ask. Thank you very much.
Great. Thank you, Jim. I think we'll pause here. We do have one more speaker before the break, but I think we'll move Crystal Witterick to after the break, and we'll take a coffee break, 13 minutes approximately.